to look at how to, let's see, how to draft a contract. There are things one has to do to draft a contract. First of all, you should use a standard format for a specific type of legal agreement. Then the contingency, you should also have a contingency that must be met in order for something else to occur. And before you consult, before you give an attorney go ahead to help you draft the contract, you should state out, first of all, draft your conditions, what you want and how you want it, the terms and conditions, and be very certain that you identify and make use of the key points in advance before the final drafting of the contract that has to be signed. Then we're going to let's see what the next slide is about. A successful contract should avoid misunderstanding, it should work, and it should ensure payment, and it should avoid liability. And once a contract is able to achieve all of this, we say the contract is a successful one. But sometimes some people do not meet up with their contracts. They don't fulfill the terms and conditions. So there should be a condition that must be met for something else to occur. It means if these things are not met, there should be options on how these issues should be addressed if they are not met. So this is that for contract. Now let's look at letter of agreement. A document that puts an oral understanding in writing in the form of a business letter. Okay. However, before you can say you want to write a letter of agreement, that means if there's no contract, you want to put up a letter of agreement, you must also seek a legal advice. Sometimes a letter of agreement is just a formal letter. It's just agree, especially something that is not going to take a long time, a period of time. It's just for a week or some days or some few weeks or probably a month at most. Instead of it actually very costly to raise a contract, you probably just draft a letter of agreement. However, use this option with care and with legal advice. Then there are times where contracts are breached. That means you could say a contract is breached if the failure of a signatory to perform, in the failure of a signatory, that is someone that has signed it to perform as agreed. The person is not meeting with the terms and the conditions. And there are ways in which this can be settled, either through in the small claims court or in the arbitration. Now let's look at what is small claims court and arbitration. A small claims court is a legal option for solving conflicts involving less than a certain sum of money. This depends on the nation and the state which this business operates, which the business is registered. Then we could say arbitration is just a method of dispute resolution using an arbitrator to act as a decision maker rather than going to court. If you must use arbitration, both parties involved, the parties involved in this arbitration process must comply with the arbitration, must comply with the final decision of the arbitrator. Okay, we've talked about arbitration, we've talked about small claims. Now, a lot of people, they just make the mistake of, I've issued contract to this person, so because of that, the person must live up to a situation. Before we talk about contracts, before you even issue of the contract, before you even consider giving out the contract, you must ensure that this person is someone that is trustworthy, is someone that that will live up to the agreement. We don't just see people knowing very well these people are not trustworthy, they are scammers, they are people that are not committed to carrying out their responsibility, and you just hide under there is a contract and issue out a contract, or go into agreement with the person, meaning using a contract to bind both of you. A contract is no substitute for trust. Okay, there someone you trust, and it's someone you trust that you can go into a contract with. This is just to avoid trouble at the later end, because this can be very, very unpleasant and difficult to renegotiate after you've signed and gone into contract with anyone. So to avoid this, if you do not trust someone, there's no need in having a contract, because the contract will not improve the relationship. The contract is only to address your concerns in writing. Okay. Now we have commercial law and entrepreneur. When we say commercial law, it's actually the body of law that governs business and commercial transaction. We also have, in commercial law, we have the Uniform Commercial Code, which is the USS. This is the collection of business laws adopted by most states that directs the broad spectrum of transactions, such as loans, contracts, and the like. This usually was first issued in 1952 and is operational in many parts of the world. I mean, specifically, okay, in the US, okay. It's not law, rather it's made up of recommendation for laws that states may adopt as written or without modification. Now, this UCC addresses issues on general provisions, okay, articles, we have Article 1 to 9, and they address issues on general positions, sales, leases, and on the secure transactions. Even up to bank deposit, letter of credit, all those ones are considered in this the Uniform Commercial Code. Now, in the common law, we have the subject of agency law. This is a vital area of the commercial contract law. When we say agent, it's actually a third party that can bring create a legal relationship with another individual or business. So the agency law is the branch of legal activity that addresses relationship between each party in a situation where one individual or company is authorized to work on behalf of another. So the law of agency relationship includes relationship between an employer and employee, the real estate agents, stockbrokers, insurance agents, and that is for financial services. It also have for modeling, acting, music, promotion. Those ones are grouped under promotion. Then, now we've learned about the forms of business, the commercial law, okay, common law and the commercial law, the agency law. Now we contracts. Now let's look at bankruptcy. Bankruptcy is a legal process in which an individual or business declares the inability or impaired ability to pay debts as they come due. Okay, once a business has filed for bankruptcy, it means no transaction is considered with that business. It means, in short, once the company has filed for bankruptcy and is granted, it means the business is dead. That business name, that entity is dead. It's gone. So over time, there are popular businesses that have filed for bankruptcy and will declare bankrupt. The General Motors, Macy's, and Delta Airlines have all done all of this. No matter the form of business, whether big or small, you can actually file and can emerge as bankrupt. So let's look at the case study of the US, see over time. Okay, this data shows from 2007 to 2017 the number of companies that has filed for bankruptcy. Oh, 2009 has a lot, 60,000 companies. Probably you will want to research on that on your own, or probably write an article on that, why there were so much companies filing for bankruptcy in the year 2009. So it could probably be due to economic meltdown, okay, and a lot of business were struggling to meet up with their debts, okay, of production. So they went bankrupt. So these are the statistics. like every country has its own rules, and every country has its own data in regards to companies that have filed for bankrupt, and how they how they were how they were made, how their issues were managed after filing for bankrupt. So talking about bankruptcy, when companies, entrepreneurs, when entrepreneurs file for bankruptcy, they may face two choices. One is liquidation or reorganization. However, bankruptcy is something a creditor will not want. They will not want, because once your company or a customer which you deal with is filing for bankruptcy, it means that you will have to wait for payment, and you may lose most of the payment altogether. Means the money they owe you, you might get little or very little out of it, and there's definitely no how you can be paid off, because there will be a lot of creditors. In the first instance, if the company was able to pay, and the company would have, the company was had the capability to pay you all of what it owes you, the company will not even file for bankruptcy. So once a company files for bankruptcy, it means that there's high tendency that you will get little from what you are owned. So we have Bankruptcy Reform Acts of 1978 and 2005, governed by the 8 chapters, which are chapter 7, 11, and 13, and generally applied to small businesses with chapter 7 and 11. This is for the USA. Okay, so you can actually find out more about filing for bankruptcy wherever you are in the country you are, or your country of origin. You can research on that. There are areas you can actually research on as students and get to know more about these things, especially if you are very interested in doing business. So now let's look at liquidation and reorganization. Let's see how this works. So for recognition, it's a form of bankruptcy that can prove to be a lifeline for a company. Business can pay off some of all of their debts under court supervision while continue to operate. You will still have to operate, but you'll be paid your debts with be monitored, okay? Or you will be supervised to do this by the court. But the thing is that the advantage is that it's like they've uncuffed the creditors. Creditors cannot file legal claims against the company. Because when they file legal claims, most times you pay more, because they will also be asking, apart from paying their debt, they'll be asking to pay for damages. So if you file for bankruptcy, and they give you the choice of they granted you the choice of reorganization, it means creditors cannot file legal claims against the company, while it creates a reorganization plan and schedule debt repayment or negotiate settlement on the amount owed. The company will not be closed down if it continues operation, but the payments, those they own, which is their creditors, will be the company will be monitored by the court, supervised by the court, for them to make payment to those they own, which is their creditors. So this bankrupt party, known as the debt possessor, gets 120 days to file a reorganization plan with the bankruptcy court. They are given like 120 days, which they must meet. Okay, so a lot of companies that had this choice, some were able to get out of it, and some could not. So let's move on. Now let's see liquidation, the choice of liquidation. Okay, this aspect of this, when this form of bankruptcy possession is sought by individual corporation, they must identify all assets and liabilities, what you have and what you own, and the assets, turn the asset over to the trustee. All the assets will be given to the court or elected by the creditors and allow them to be sold. So these assets will be liquidated, and creditors will receive funds from the proceeding ranging from 0 to 100%. This is percentage based on what you own and will be paid of their debt claims. Once these funds are paid out, any remaining debts are discharged, means you are not owned. So no longer this chapter 7 liquidation also affects the debtors. They will be made like this because some companies are crooks. They are crooks when they know they are almost filing for what do you call it? They are filing for bankruptcy. They try to do away with their assets. Okay, so however, this chapter 7 ensures that any transfer of property within the 2 years prior to filing may be ignored and the asset made a part of the bankruptcy case. Such assets will be ignored and will be made part of the bankruptcy case. This is why that debtors cannot avoid the liquidation of assets by transferring ownership to others just ahead of filing for protection. So this is chapter 13. All of them all have their condition. Okay. Chapter 13, individual debt reorganization. Chapter 8 talks about the individual debt reorganization. This you can read about and also find out how all of these things, liquidation, bankruptcy process works in your country, your country where you are at. So now let's see. Let's look at protecting intangible assets. This has to do with intellectual property. This is a very critical practice for any entrepreneur to protect his or her ideas, products, inventions, and design. Now, it's not only physical assets to protect, even intellectual property, like your invention, your ideas, designs, all of these can be protected. This is why federal and state laws are designed to help individuals and organizations protect these kinds of assets from abuse, reputational damage, or theft. So we also have the trademarks and service marks. Service marks is a design that identifies and distinguishes the source of the service rather than the product. Whether you're advertising your business with flyers at the local laundromat or through a storefront on the internet, you will need an easily recognizable logo. Okay, the logo for your business or product. Then of course, all products have logo. Okay, my best logo is the Apple logo that shows a bite, right? So that is an example there. The Apple logo is just an apple with a bite, a bite of it. So this logo should appear on the business stationery tool, your business cards, flyers, and virtually any other company documents or product. Now, trademark and service mark actually have oppositions. In the US, they have what do you call it? Institutions that are in charge of them. They just ensure that they give all the service in regards to this. And for example, if you're outside the US, you as well use the International Trademark Association to help yourself. It can help you apply for a community trademark, which provide trademark protection in the European Union. Okay, we also have copyright. A copyright is a form of legal protection offered under the US law to the authors of original work of authorship, including literary, dramatic, musical, and artistic work. Okay. So, if you are a songwriter, author, or visual artist, you will be creating works that you might sell. You might be able to sell that, and your work will be protected. Someone else cannot appropriate it. Okay. So according to the Copyright Office, the work is created. When can it be considered that the work is created? The work is created when it is fixed in a copy or fully recorded for the first time. So starting from the very first day it is fixed in a copy or a fully record. Then the very first day. Okay. Now we're going to look at the copyright. This copyright is one of those what do you call it, intellectual property protection. Even some of us will use, especially those that have written their thesis. Normally this should always require you to put this. Okay, the symbol for this is a C that is circled. So this actually is to let people know that it's the elements of there, and you also put the current year and name. Okay, and once everyone sees this, it knows that the owner, and you cannot just make copy without letting the owner know. Okay, and sometimes you must also give credit. Yeah, give credit to the owner when you do that. That is why even when you on social media, when you write statements that are not originally yours, you should always state where you got them from, copy from, or reference from. Okay? So in one way or the other, we just do copyright. We just copy people's work without even knowing. Okay, so such offense is actually can be suable. People can sue you, and you'll be made to face the consequence of doing such thing. So for little things to big things, you should always seek people's permission to use their work, physical and intellectual, and you should give them credits even if you could not reach out to them. When you give a credit to people that owns the original work, you're not stealing it, because even though you've put it out there, you still have to state that you got it from the original name is out there. And this is why when you write research papers, articles, it's the publishers or the committee, the research committee, okay, they always insist you put your references. Okay, it's a criteria for your work to be published. You must put your references. So whether you are adding to it or not, you must put your references. Then we have electronic rights, the right to reproduce someone's work online. Now that writing, photographs, and art, this I just discussed about now, and we'll just move to the next slide. So to protect your electronic right, beware of contracts that include the following when you want to sign. A lot of us, we just join social media rights on these social apps. We don't even get to read about the agreement. You just say, if you agree, say yes. You just say yes, everything say yes. You just click yes, and that is all. What you are just interested in is that you've opened the social app and you are active there. So you should, when you do that, you should be aware of things like this. Take your time to really decide if you want it like that. Especially when you see what is like work made for hire. This means you are giving up the rights to your work. Now the buyer can use it anyway, even without paying anything beyond the original negotiated fee. And you should also watch out for words like all rights. Okay, there's all rights and all rights reserved. Okay. All rights reserved, you could see it in this one. Let's the example here. I think it's okay. Let's move on. All rights means you are handing over all rights to your work to the buyer. There's no one reserved. So look at my slide. We have all rights reserved there. It means that your copyright 2020, basic education, and operation, all rights reserved. You don't have any right to publish any part of this without stating them. have patents, we have public domain. So patents are an exclusive rights granted by the government to produce, use, and sell an invention or process. Then we have public domain. Property rights are available to the public rather than held by an individual. So if you have invented a product or process that you want to turn into a business or to license, you may want to obtain patents. Okay, many countries, they have their patents and trademark office where you can actually patent your work and get a trademark. So, but you cannot get a patent if you have invented a product that you intend to market. You can only get it, but you do not need to obtain a patent unless, that means you can only get a patent if you have invented a product you intend to market yourself or sell to a manufacturer, or believe that someone else will successfully sell your invention by copying it. These are only the ways in which you can get a patent. So, I mean, you cannot plagiarize someone's work or copy someone's work and want to get a patent from it. That is criminality. It must be something that you invented, you own, okay? Something that you own, that you either want to market yourself or you want to sell to a manufacturer. Okay, so moving on to the next slide, we're going to look at protected tangible assets. This has to do, we've talked about intangible stuff. Now let's look at tangible assets, that means physical assets. Those ones are more like risk management. How do you manage them? In addition to protecting your intellectual property, you should manage risks by protecting your physical property too. Okay. Imagine if you lost your business to a fire or flood, which is very possible these days. Yeah, you do not have any insurance coverages. That means if you lost them, you lost them forever. Most times, most businesses cannot come back. I mean, you cannot recover from this type of incident. So, first of all, let's understand business insurance. Okay, it's a good start. However, when we say risk management, it goes beyond insurance, and because starting from insurance is a good start. So first of all, when we say insurance, we have it's a system of protection for payment provided by insurance companies to reimburse individual and organizations when their property or wealth has been damaged, destroyed, or lost. So once you are involved with insurance, you should be very conversant with words like premium, deductible. Premium is actually the cost of insurance. Then deductible is the amount loss or damage the policyholder covers before the insurance pays on the claim. So we have many types of insurance, very many, yeah, and there are even more in those advanced and developed countries. Okay, so let's look at some of this insurance. Before then, you know, before you can have insurance coverage, you must be ready to, apart from one of the restrictions, one of the requirements that you should be able to pay premium for a certain period, okay, based on the terms and conditions. Basic coverage for small business insurance would be property insurance. For small insurance, disability insurance, product liability insurance, key person life insurance, errors, and all of these are explained in this slide. These you can go through. These are the types of insurance you can insure your business with or yourself with. There are basic coverage for small businesses. This you have to do. In some countries, once you open a business, one of the requirements to get you registered is that you must have an insurance company you've registered your business with. But in some other countries, they just let you go and you put people and people's investment at risk without no insurance coverage. So it's very important you know about all of this. And sometimes it's not even advisable you invest in businesses that do not have insurance coverage. One of the criteria to know into the business you want to invest in is trying to look up companies or corporation you want to work on, try to look at their insurance these are other useful types of insurance, like the liability insurance, product liability insurance, property insurance. Then we also have business income insurance, errors and omission insurance. I imagine that these are actually designed for service businesses. It's designed to cover you in the event that you have overlooked something and the customer is armed. I mean, you overlooked something, I mean, per site, right? And in that process, someone gets harmed, or there's an insurance coverage for such problems, okay, issues. So we also have key person life insurance. So all that you can read on your own. How insurance company make money? So if you wondering, are they Father Christmas, or are they chef, what do you call it, angel investors, or what are they? They just pay off for people's losses. I mean, how do they do it? So by now you may be wondering, how can insurance company afford to pay 150,000 to a restaurant owner, right? So the thing is that insurance company employ experts as actuaries. They are called actuaries. Okay? This expert will actually analyze any loss. They study it, analyze any loss. Okay, first of all is that they actually assess any person or company that want to get insured. They calculate the odds of a particular event actually happening. Maybe for example, a fire outbreak. And for example, a company that specializes in fire insurance will have information about fires in restaurants. They will come and look at the vicinity, the environment, okay, to ensure that there is no fire risk in that area. Because some people, they themselves, they will cause this problem, and they expect the insurance company to pay because they've not taken precaution, they've not put prevention into place. All they just do is that, oh, I've insured myself against fire, so the next is to let the gas leak. So once the gas leaks and there's a fire outbreak, the insurance company is going to pay. No, insurance company, before they even accept to insure you, they come to your facility, they study it, they ask questions. Okay, you understand? If it's a company that there's always high tendency of fire outbreak, you'll be paying more premium. Yeah, compared to someone that will not is not exposed to such problem. Also, that is not exposed to, okay, I'm using fire outbreak as an example. Compared to someone that will not be exposed to such fire outbreak. So, for example, you are also someone that you want to insure your let's say for example you want to insure hazard. I mean, you're insuring yourself about job accident, and the kind of job you are doing is in a very good environment, secure place. You don't have problems of dangerous things around. You pay less than someone that is in that out there in the field, like someone that is in the war zone fighting, that has the high tendency to have problem. Okay, definitely one accident or the other, as the case may be. Okay, so that is that for insurance company. They specialize in they employ experts to actually to calculate the odds of a particular event actually happening before they know how to deal. Then, because your computer is an electronic device, you should protect it from 3 primary occurrences that easily wiped. All of these are just explained. You say because you've insured your laptop, for example, your computer. So the next is that you will not protect the computer from viruses or disk failure or power surge or outages. You just feel it's already insured, so I can do whatever I like with it. So when there is a problem, okay, when a problem occurs, don't be surprised you will not be paid. There won't be any compensation. Yes. And at the same time, it's fine if you still intend to, if the insurance company still intend to go with you and get you insured, you will pay more premium. You pay more premium compared to someone that has all of these things in place to protect his or her computer. So moving on, we have what they call design disaster recovery plan. Okay, insurance policy may cover many things, but they do not ensure smooth business operation in times of disaster. They do not. So you must have a disaster recovery plans, because sometimes before you can get compensated by insurance company, it takes a long time. They must ensure that you everything was, it's not fake. Okay, it's not fake. The incidents that happen is based on the agreement. Okay, if you insure your car against theft, it's not the same thing you insure your car against fire outbreak. They are not the same thing. So if you insure a car against theft or fire, or in whatever way the car still got missing, because if it's against theft, the car you lose the car, and if it's against fire, you lose the car. But insurance policy will ensure, first of all, to investigate to ensure that what you actually insure the car against is what actually happened to the car. Because a lot of people fraud the insurance company, fraud them a lot. They insure themselves for one thing or the other, and they make things happen that is not what they insure themselves against, and they claim. So to avoid all of these problems of being frauded, okay, the insurance companies, they take their time to make to give out their compensation. They take their time to investigate, to analyze what has happened. So this is why you must have a disaster recovery. You should have a disaster recovery plan, whether you operate a small home-based business or a large multinational enterprise. You should have a disaster recovery plan appropriate to the scale and complexity of your organization. Okay, that is all. I think that is all about insurance company. Okay, now if we're talking about disaster recovery plan, what are the issues this disaster recovery plan is supposed to address? It's supposed to address your communications. Okay, especially if you're a big corporation, you should address your stakeholders, your customers, your creditors, your debtors. Don't let them sit down and wondering what is happening. There must be communication. You have to bridge that communication gaps. Then address issues that are based on operations, then priority activities. Maybe there are people you're supposed to give a supply of that day the incident happened. Before the fire outbreak, you must reach out to them. Okay? Return to facilities. How you have to return. All these plans must be put in place, just in case anything happens. The insurance company is taking their time to compensate you. Okay, so it doesn't mean you have to fold your hands and legs and wait on them, because sometimes the investigation might be not about when they investigate and they see that you are not supposed to be compensated, and you waited that much for them. You waited a long time waiting for them for compensation. Then in the long run, you will not be compensated. It's even more difficult for your business to survive with the outcome. So while waiting for them, there must be recovery plans in place in regards to all of these mentioned. Your communications based on operation, priority activities, and return to facilities as for you hear from the insurance company. Now we're going to talk about license, permits, and certificates. Permits are official documents that gives the party the right to hold the specific events. They are an official document that grants the right to engage in activity for a special period of time. That is what the license is. Then we also have a certificate, an official document that verifies something. So all of these, you might need to have all of these to keep your business running, or maybe one or two. However, you must be sure of what your business needs. Okay, you must be sure to know how to get all of this if it's a requirement for your business to run. You should research this regulation before deciding to start your business, because they may affect what you can do and how you can do it, or where you can operate and when. It could be that in some companies, some kind of business you are running, and the place you are running it, the people there might not be willing to give you the permit necessary, because every country has its rules and regulations. Some countries are very all of this, and some they are very strict. They tell you they cannot issue you the permit or license you need to do a certain thing. So all of this you must research and find out before you start off any business, so that you don't face